Before we get started, I want to go ahead and go over the GoToWebinar interface with you. You should have on your left here a screen viewer where you can see the PowerPoint presentation. On the right, you have a control panel. This is a great time to test the audio quality of the presentation. So if you're having trouble with the audio, you can use the telephone or the computer or your computer's mic speakers. To use the computer's mic and speakers, you need to select mic and speakers from the audio pane. You can also minimize the control panel by clicking on the double arrows. You can maximize the control pane by doing the same thing, clicking on the double arrows. Your other option for audio also is to use your telephone. So you can click on Use Telephone in the audio pane. And in the audio pane for telephone, you'll see the dial-in information that you can use to connect to the webinar via phone. Today you are all muted due to the size of the audience, but we welcome you to submit questions in the question box, and we will try to answer all of them towards the end of the presentation. Just a few more housekeeping things before we get started. The materials for this webinar were emailed to the registrants this morning, and we will be emailing them out again after the webinar along with evaluations and a recording of this webinar. All the materials and the recording will be posted on our OVW grantees website at nhlp.org. This is the URL here. And for California attorneys seeking CLE credits, we will be sending out the MCLE certificates for these attorneys in about 2 weeks after the presentation. So with that, I will go ahead and turn over the presentation to Claire Johnson, who will begin the substance of the session.
Good afternoon, everyone. My name is Claire Johnson. As Carla said, I'm an attorney with Bay Area Legal Aid. Hold on just 1 second. There we go. So before we get started, I want to let you all know that I'm going to cover a fair amount of material in the webinar this afternoon. I'll be talking for a little over an hour, and then we'll have some time for question and answer session. If you have questions while I'm talking, feel free to submit those through the chat function in the webinar. Carlo will keep track of the questions that come in, and I'll address those questions at the end of the webinar. At the end of the webinar, I also provide you with my email address and my telephone number. Do feel free to email me directly or give me a call if you come across clients with the issues we're talking about today. I know that for sort of some of the frontline service providers for domestic violence survivors, you come up with an issue, you're not exactly sure what to do, but if something rings a bell and you remember me having talked about it in the webinar, feel free to send me an email and I can provide you with sample materials or a refresher on what we talked about or an analysis of your particular case, okay? Also, if you contact NHLP for help and they've got something that I can help with, they can also refer the issue to me. So first of all, the goals of our presentation today, by the end of the presentation, hopefully you will be able to understand the role that consumer reports play in accessing rental housing. You'll be able to help your survivor clients. Oh, hold on just a moment, please. Okay. You'll be able to help your survivors to obtain and understand credit and tenant screening reports. You're going to learn a little bit about the laws that protect consumers. I know that we have a national audience today. So the Fair Credit Reporting Act is the law, the federal law that applies all over the country. And there's another law that applies specifically to California called the Investigative Consumer Reporting Agencies Act. You'll obtain some tools to learn how to dispute errors on credit reports and understand the basics of credit scores. We're also going to talk about helping survivors prioritize their debts. And Carlo will talk for a little bit about special state protections for survivors of domestic violence in the rental housing context. So we're going to start off with a poll. Carla's going to pop up with the poll on your screen, so that should appear for you here in just a minute. I'd like to know how many of you, whether your organization includes questions about financial abuse during the screening and intake process. So go ahead and answer that question, and we'll come back to the poll responses in just a moment. So why is it important to screen for financial abuse? It's important to incorporate questions about credit and banking and debt into the domestic violence intake interviews. We want to know about prior economic harms. One of the reasons that we want to do that is if you're one of the frontline service providers who's assisting with a protective order or restraining order, it's good to document prior economic harms in your client's declaration that you attach to that. If she didn't have access to the bank accounts, if she wasn't permitted to work, if he, for example, declared inaccurate information on taxes, you want to put some information into that declaration that she did not know what was going on, or she did not have control, or that he may have opened accounts in her name, because then you have something documented and filed with the court that you can use as evidence later in order to help remedy certain situations. For example, if you're seeking relief from the IRS for innocent spouse relief, or if you are seeking to establish that a certain account was opened as a result of identity theft, that the abuser opened that without her consent, without her knowledge, and that she didn't benefit at all from the opening of the account. That is identity theft under the law, which we'll talk about more in a few more minutes. You want to ask about control over and knowledge about financial resources in the home. And that's, first of all, to establish that record again and evidence. And also we want to educate judges out there, right? We want to educate judges to understand that domestic violence is, the entire cycle of domestic violence, the entire abuse cycle involves a lot more than just physical abuse. And lack of abuse, lack of control over financial resources is one of the things that keeps our domestic violence survivor clients from exiting an abusive relationship. So it's important to ask questions about that in order to help our clients more holistically, so we can understand what's going on and help them provide for future economic security. This is important for divorces. This is important for providing information for a family law attorney who might assist your organization by providing services for getting a client's divorce started. It's important to know, depending on whether or not you're in a community property state or not, but it's important to know for access to property to which the domestic violence survivor is entitled. It's also important for asking for a kick-out order or rental repayments in your restraining or protective order. And what's the best source of information? The best source of information is always the client's credit report. And everybody who has either an ITIN or a Social Security number has a credit report. And the best place to go for a credit report, we'll go to that in just a couple of minutes. There's a screen that has the information, but it's www.annualcreditreport.com. Anything that has the word free in it, if it relates to your credit report, is not actually free. Anything that advertises on TV about your credit report is not where you want to go. Anything that sends you an offer in the mail and offers to monitor your credit reports or give you credit reports is probably going to sign you or your client up for a service where you're paying $15 to $25 a month. And before you know it, you or your client has paid $100 into a program that you didn't mean to sign up for. Every year, everyone is entitled to a free annual credit report from the major 3 credit reporting agencies. And you can get those at annualcreditreport.com. That URL is in a couple of screens. We'll have it up here. So why is it important, and why are our domestic violence clients specifically vulnerable? Why is this a specific issue for our DV clients? Debt collectors can further traumatize survivors. Debt collectors are known to use very abusive debt collection methods. Dealing with a lawsuit on top of everything else that a survivor is going through when she and her family are trying to get reestablished away from an abuser, the last thing she's going to want to deal with is a debt collection lawsuit. Old debts can haunt survivors for years when they try to obtain housing or loans or credit cards. So make sure we get those consumer reports. It can lead to debt, bankruptcy and foreclosure issues, or it can lead to high-cost credit, right? Somebody who has a bunch of debt on their credit report is going to end up with a much more expensive car loan or a predatory car loan instead of a good interest rate on a car loan. There's specific factors in our DV client population that make these folks specifically vulnerable to some of the issues we deal with as consumer rights attorneys. Frequently, an abuser will use his victim or the survivor's information in order to perpetrate identity theft. If a DV client is in crisis, she generally has an inability to budget due to the crisis, or frequently. The lack of control over financial resources and decisions is also leads to some of these consumer law issues. And frequently we have clients with limited English proficiency or sometimes with limited education who don't have, who don't have a working knowledge of what's going on with the financial resources in the home. So Carlo, can we go to the poll results and we can see how many people are currently screening for financial abuse in the intake?
Sure. So it looks like about 31% of the audience does screen for financial abuse during the screening or intake process. About 33 do not, and then about another 37% do that practice sometimes.
Well, that's wonderful. I'm glad that this is on we're on most people's radar a little bit. At the end of the presentation, on the same screen that has my contact information, there's a link to a national organization called the Center for Survivor Agency and Justice, and they've come up with a screening form. This is a screening form for advocates for domestic violence survivors to use to screen for consumer law issues. So if you follow through on that link, you can find a pre-made form and you can incorporate some of those questions into your intake process. I also provide a link to a book that is called Consumer Rights for Domestic Violence Survivors. It's a very accessible book and has some additional information. So let's get started by we'll talk about joint bank accounts and submarital debt. There's a relationship through the family law courts that's created when two people get married, and that is different depending on whether or not you're in a community property state or a non-community property state. However, your client's relationship with her creditors, including with her bank, has got to do with the contract she signed when she signed up for that account. We'll talk about this a little bit more in a second. But if your client has a joint bank account with her abuser, what that means is that either account holder can take all of the funds out of that account. Generally, neither account holder can close the account unilaterally or remove the other person from the account. So if the parties are married, they might be required to return 50% of the funds. So generally what we like to advise clients to do with a joint bank account is advise her to open a new bank account right away. She can remove funds she reasonably believes are hers out of a joint bank account, and she can put them in her new individual account. We recommend she open a new account when she first separates from an abuser, because if the abuser goes and messes up her bank account, she's going to have a hard time opening a new account if he overdrew the last one. Bank accounts are important for applying for housing. That's something that improves your tenant screening report. So it's important to act proactively and go ahead and get that open. We do recommend that she opens the account with the funds she reasonably believes are hers, and that's a specific, fact-specific question. What funds are actually hers, and it may differ according to your state law, depending on whether or not you're a community property state or not. Okay, again, just because parties are married, each party is going to have, or everyone who signs up for a credit card, if you sign on that contract for a credit card, you have a legal relationship with the credit card company. So if you've got shared credit cards between the abuser and your client, you need to understand the difference between an authorized user and a joint credit card. So if it's an authorized user, that means that one person opened it and gave someone else permission to use it. So if you've gone and opened a credit account in your name, they will frequently ask, would you like to add someone to this account? And someone can be added to another person's credit card account without their consent and without signing up. So if you're an authorized user on someone else's account, you're not contractually obligated to pay on it. That means you can't be sued on it, and debt collectors can't force you to pay on it. So when you pull your client's credit report, you want to see what kind of account is each credit card. Is it a joint account, which means both she and the abuser signed up together for the card? Is it an individual account, which means she is the only person legally liable on that, regardless of who charged on the account? Or is she an authorized user, which means that it's going to get reported on her credit, but she cannot be, there are no legal methods to collect from her because she's not legally obligated. She never signed her name to sign up for the card. So as it says on the slide, the creditor cannot collect from or sue an authorized user, but that account history is reported on her credit report, and there's really nothing you can do about it except get her off. If she's the authorized user, call up as soon as you see that and say, please remove me as an authorized user from this account. So as soon as you request to be removed, it will stop reporting. If she is the account holder and the abuser is an authorized user, you want to remove the abuser from her credit cards as soon as possible, okay? So anything you see that you know that she authorized him to use the cards, call up those credit cards and take him off of them. However, if both parties signed up for the credit cards together, meaning when you read on the credit report, it says joint account, the creditor may attempt to collect from either joint account holder, meaning the creditor can sue either of them or both of them. If under community property laws, so if you're in a community property state, and I can speak to California here, you can allocate the charges to each spouse in a divorce judgment. But unfortunately, that doesn't matter to the creditor. The creditor doesn't care what the divorce judgment says. The creditor can still sue either party who is an account holder. So it's important to know that just because your client gets a divorce judgment that says he owes all the money on the credit cards, if the credit cards are in her name, she can still be sued, okay? More specific questions on that are sort of family law questions. So if you have family law attorneys available as resources within your organization or resources for your organization, you can ask those state-specific questions regarding offset or contribution in the divorce. So as I just mentioned, so if you have individual credit cards with charges incurred, this is a little bit California specific, but community debt in a divorce can be allocated 50-50 to each party. The charges after the date of separation belong to each individual, but the creditor will sue the person whose name is on the card. So again, check your local laws for non-community property states, because I can't necessarily speak to that as a California attorney. how do you get a bank account if you have bad credit? There are opportunities. So if you screwed up your bank account or the abuser has screwed up the bank account, the problem is a database called check systems. So if an account gets overdrawn, that person gets reported to a system called check systems. If an account has been overdrawn, you can remedy that problem by paying the balance. However, if check systems is reporting suspected fraud activity, it's hard to get off of check systems. But you can assert identity theft if the abuser was responsible for the fraud activity. Here in California, there are a number of programs under the Bank on California program that permit people to get bank accounts even with a history of bad credit, or for people who don't have a Social Security number. So if you're here in California and your client is unable to open a bank account due to being on check systems, she should look up the Bank on California program and look for a local participating bank or credit union. I generally recommend a local credit union over a major bank. The local credit unions tend to be more willing to give people a second chance and listen to their individual stories. Sometimes it's even a good idea to go into your local branch with your client and talk to a branch manager and advocate on her behalf and explain that any prior bad activity on a bank account was the result of the abuse in the relationship and that she's starting over and she really needs a second chance. Wells Fargo Opportunity Checking does have a second chance banking product, but sometimes Wells Fargo will open an account for a client and then turn around and close it a couple weeks later because of check systems. Again, if you have a local credit union, I recommend that over one of the major banks. So let's go ahead and define what we mean when we say consumer reports. Consumer reports is a large umbrella term that refers to anything that includes any information about a consumer's character, general reputation, personal characteristics, mode of living, and it can include credit, criminal record, and civil judgment information. So this means that a background check is a consumer report. A credit report that you apply for when you try and get a loan is a consumer report. When you apply for a job and they run a background check, that's a consumer report. And when you apply for a place to live, which is most of what we're going to talk about in the next few slides, that's also a consumer report. So a tenant screening report is a specific kind of a consumer report. It's compiled or created by a specialty consumer reporting agency. And it's usually compiled from multiple sources. So the credit information on a tenant screening report is usually from one of the major credit reporting agencies. Those three are called TransUnion, Equifax, and Experian. And it's those three that you can get your credit information from by going to annualcreditreport.com. Your criminal record information comes from public record data. So these companies send out people to the courthouses to go collect information about criminal records and then report back. So as you can imagine, there are lots of opportunities for errors and mistakes and mixed up names when it comes to criminal record data. Civil judgment information, and this includes, in California, we call an eviction an unlawful detainer. So if I say unlawful detainer or UD, I'm referring to an eviction for those of you who are in other states. But so civil judgment information comes also from public record data collected by private vendors. So again, there are many opportunities for mistakes, especially for people with common names. So who is allowed to request a consumer report? A user of a consumer report, so that would be like a landlord or an employer or a auto dealer lot. So that company or person must have a permissible purpose to request a consumer report. So when your client applies for a place to live, she gives consent for a consumer report to be obtained by the landlord. Other reasons that it would be okay to get somebody's consumer report would be to collect a debt for certain kinds of employment, or to make a decision about extending or offering credit. It's not okay to go get a consumer report, for example, on the abuser. So it's not okay to pull someone else's credit report, because under the law, you have to have a permissible purpose to request a consumer report. So if your abuser wants to know where he's living, where he's working, what other stuff he opened in his own name, unfortunately for her, but it's a privacy issue. So you cannot request the abuser's credit report. And likewise, the abuser can't turn around and access your client's credit report. But he may be able to if he's got enough information to do that. So here's the URL that I promised you. How do you obtain a consumer report? So before a domestic violence survivor applies for housing, we want to know what is on her credit report. We want to look for unknown accounts. Anything she doesn't recognize that's in her name, you can flag that as ID theft, and you may want to place a security freeze with the credit reporting agencies, those big three that we mentioned earlier: Equifax, Experian, and TransUnion. You go to www.annualcreditreport.com. You get a free copy every year. Now, this only gives you the three that I've listed here: Experian, Equifax, and TransUnion. We'll talk in a couple minutes about how to get a credit report if you've been denied for housing, or the tenant screening report. So you want to print a hard copy of each report. You kind of want to do everything on paper when it comes to the credit reporting agencies, because they have a tendency to lose things. They have a tendency to require people to waive their rights in order to use online services. It's better to print stuff out and have a hard copy. It's very important to keep a safe address confidential. You don't want to report your old address, or you don't want to report your current safe address to the credit reporting agencies, because if the abuser has access to a client's social security number and birth date and prior addresses, he can pull up her credit report. Now, if she's pulled her credit report already, her new address will be reported on there. So it's very important that you can use an old address. You can use, in California, we have a program called Safe at Home where you can get a P.O. box. I know many states should have a program like that for domestic violence survivors, where they can use a P.O. box. Maybe your shelter or service agency assists with providing confidential addresses. So a confidential P.O. box is fine, but do not put down the address of your shelter or your legal services agency. You don't want to get your organization's address mixed up there with her credit history. And neither, if she's staying with family, friends, or has a new place to live, you do not want to list that address in the request for the credit report. If a client has insufficient knowledge for an online request, generally they're going to ask some questions when she applies for her free credit reports. And they ask questions about, did you have an account, for example, did you have a mortgage in 2006? If the answer is no, you put no or does not apply. This doesn't mean that someone opened a mortgage in her name. It simply means that someone with a similar social security number or birth date or name may have opened a mortgage, and they're trying to make sure that you have the right person. So just because it asks some questions that don't apply, that doesn't mean that she's the victim of identity theft. You've got to wait until you get the credit report and look at it to know whether or not any accounts were opened in her name. So don't jump to conclusions based on what are basically some security questions they ask at the beginning. If a client has insufficient knowledge for the online request, this happens sometimes with younger clients, or immigrant clients or people who have a relatively short credit history. They'll have insufficient information in order to verify who they are online. So then you have to request by mail. Annualcreditreport.com also has a way to request by mail. You'll need to send in a couple of verifying documents, including a copy of her identification and Social Security card. If the address has changed from the time that she had from the address on the Social Security card, you will need to provide one other additional piece of documentation, like a pay stub, a letter from Social Security, a letter from General Assistance, a letter from your shelter saying that she's living there, that verifies the current address. Utility bill, I think, are a couple of the other ones. So she can change her cell phone billing address to her current address and then provide a cell phone bill, for example. So in order to dispute inaccurate information, you need to send a certified letter from your client. And if you have inaccurate information on a consumer report and you want to dispute it, you can send me an email and I can send you a sample letter. These are letters that will work all over the country because it is a nationwide law called the Fair Credit Reporting Act that you enforce your rights under. So you want to provide as much information about the dispute as you have. At the end, we'll talk about this last bullet point in just a few more minutes. When I say provide a letter of explanation, providing a letter of explanation to the credit reporting agencies doesn't do much good. But you can provide a letter of explanation to housing providers, to potential landlords. And we'll talk about that in just a couple of minutes. So how do you obtain a tenant screening report? What if your client got denied for housing and you don't exactly know why? It just says she's supposed to get a letter upon denial of housing, and that's what we call adverse action. And a landlord is supposed to provide a notice when they deny somebody for housing, and it's going to have a toll-free number that your client can call. She has 30 days to get a copy of the report. There's no central database of tenant screening reports or employment background check reports. You've got to call the specific tenant screening agency that denied you. And the only way you know who denied you is from this adverse action letter. In theory, you're entitled to a free report from them every year as well, but most tenant screening companies claim that they don't keep a file for somebody until a landlord requests that they put it together, that they compile it. However, the same dispute mechanisms that we talked about here, sending a certified letter from the consumer, keeping a copy of all communication, providing as much information as you have, those dispute mechanisms under the Fair Credit Reporting Act also apply to all the other stuff that you're going to find on a tenant background check report, which includes criminal record information or eviction record information. But you've got to get a copy of the report to know, and that has to happen within 30 days. So you want to tell your clients up front when they go apply for housing, if they get a denial letter, they need to bring that back to you. And you and the client need to sit down and call that 1-800 number and get that back. Especially if she doesn't think that there's a whole lot going on there. We want to see what's going on, and maybe there's inaccurate information that's causing her to be denied. We talked earlier about check systems. Check systems is also a specialty consumer reporting agency that's used by banks to make decisions about opening checking and savings accounts. So again, Check Systems is also a consumer reporting agency. And upon notice of an adverse action, which would be a written letter denying a bank account, the consumer may call the 1-800 number within 30 days and request a copy of the report. The same dispute process as we talked about, right? Send a certified letter from the consumer, keep a copy of all communication, provide as much information about the dispute as you have, also applies to check systems. And again, I can provide you with these sample letters if you run into the situation that you've got inaccurate information on one of these reports. So the Fair Credit Reporting Act is a federal law, and it protects consumers against reporting of inaccurate or outdated information. So it's a federal law. It means it applies in every state. It requires that if a consumer reporting agency, and remember that means the credit reporting companies, that means a tenant screening company, that means a background check company, or check systems, they must report 100% accurate information. Now, they're not required to report something. So sometimes you get a client who came in who says, look, I had this loan and I paid on it and I did a really good job. Why is it not on my credit report? Because the lender didn't choose to report it is why it's not on the credit report. There's no way that you can require a lender or a furnisher of information to report something that's a positive information. They can report or not report as they see fit. However, negative information may only be reported for 7 years, and it's 7 years from what we call the date of delinquency. So it's basically 7 years from when you stopped paying on it, or 7 years from when that debt went bad. Public information must be complete information. So if it says there was a eviction filed against your client, but it doesn't say the outcome of that eviction. So for example, she and the abuser were living in a place together and an eviction was filed, but they moved out. So there was never any judgment in court for the eviction. Instead, the case was dismissed. That needs, the tenant screening report needs to say on it, dismissed. So if you get a copy of a tenant screening report and it just says eviction filed, but it doesn't say case dismissed, you can file a dispute asking that they update that information. So she can say, look, yeah, they filed an eviction, but the court never entered a judgment for it. The case was dismissed. So she has a right to dispute inaccurate information, and she has a right to have that inaccurate information investigated by the Consumer Reporting Agency, and they've got to investigate it within 30 days. If they can't verify it, they've got to take that information off the credit report. Here's how you dispute an inaccuracy. You send a certified letter, return receipt requested. It costs a few dollars, about $5.90. You don't want to use the online dispute process. If you do use the online process, you lose your rights to litigate a case in court if later this turns out to be a viable claim against the consumer reporting agencies. And it's harder to track the progress of the issue if you need to refer it to a lawyer later down the line because the problem's not getting resolved. You need a paper trail. So the dispute triggers a reinvestigation of the issue within 30 days if your client was denied something, housing, employment, a bank account, a loan, or 40 days if you just pulled that credit report to take a look at it. You want to include a copy of the credit report and you want to circle the error. If there's no response in 45 days, you want to send a follow-up letter insisting that that information be deleted. And the dispute addresses, either you can find those on the websites for the credit reporting agencies or I can give them to you. So if you send me an email asking for a sample dispute letter, I'll also provide you with the addresses depending on what credit reporting agency or background check company you're trying to dispute an issue with. So let's talk for a second about identity theft and credit reports. Both the Federal Fair Credit Reporting Act and California laws protect victims of identity theft. Under the federal law, if you give notice and proof that an item is a result of identity theft, the Consumer Reporting Agency has to remove that information within 5 days. So what's proof? Proof is something that you swear under penalty of perjury that you were a victim of identity theft. So you want to include supporting documentation of you swearing or your client swearing that this is what happened. A police report is good. Federal Trade Commission affidavit of identity theft is also good. You can find the FTC affidavit of identity theft. It's an online form you can fill out, and that you can do online, but print out a copy of it and send it in with your identity theft letter. Or go to your local police, have your client go to your local police department or go with her to report identity theft. Now, you can report something as identity theft as long as your client did not know about it and did not materially benefit from it, right? So if the abuser, if you pull the credit report and there's a bunch of accounts on there that she didn't know anything about, even if they were married, it's still identity theft because she didn't know anything about the accounts and she didn't, to the best of her knowledge, none of those credit cards were used to purchase things for the family. Now, if she did know about it, but she knows he didn't purchase anything for the family, she didn't benefit from it, well, you can still argue that that's identity theft, that she was unable to raise that issue with him because of the abuse in the relationship. And for that, you'd want to document that in the police report or the FTC affidavit of identity theft. If, however, she knew about the credit cards and they were used to buy things for the household, you can't really, with a straight face, say that that's identity theft. It doesn't really meet the requirements under the law. However, if you know the size of the charges catches her completely by surprise and she has no idea what those charges were, she can request a copy of what the charges were from the credit card account company and take a look at that and go, oh, well, he went off and purchased, you know, all these things, all this money was spent at the casino or whatever. Then she can say, well, look, he used my identity, he opened credit cards in my name, and he spent this money on things that did not benefit me. Now, she needs to be willing to assist in any criminal prosecution of the ID theft. Family ID theft is a little bit difficult. You have to, the victim needs to be willing to participate in any prosecution of the thief. Most local police departments do not have the resources to go after individual identity theft issues, and the Federal Trade Commission does not do investigations of individual cases. So I can't speak for every state, but at least in California, there doesn't tend to be a whole lot of investigation of individual identity theft unless it's like an ID theft ring. But your client needs to be willing to talk about the theft and to participate and provide information should there be any investigation. So you can place a 90-day freeze on your client's account, or she can, by calling these the phone numbers listed there. She can place a permanent or a semi-permanent 7-year freeze, which can be renewed by sending a request by mail and including a police report. So if she thinks there's ID theft, that 90-day freeze is a great thing upon separation from the abuser. If she thinks there's a risk of ID theft, that 90-day freeze is a great thing if she thinks that there's a risk that he will retaliate for her leaving by opening accounts in her name and racking up a bunch of stuff. If you put a freeze on a consumer's account, no credit can be opened in her name for that 90 days. If you put a 7-year freeze on her account, she has to establish a personal identification number. And every time she wants to open credit, they call her up and ask her for that personal identification number before they open credit. So, what about identity theft and eviction records? Eviction, we say in California, we say an unlawful detainer, but we'll say eviction more generally because we got people from other states. So eviction records are public records. If your client actually lived there, you can't really get that public record off. She may just simply have to explain the eviction to future landlords. The dispute process will not remove an eviction if she was actually on the lease and an eviction case was filed. Evictions, judgments, and filed cases remain on a tenant report for 7 years. Now, if somebody illegally used your client's identity to rent an apartment, you do want to file a dispute with the tenant screening company and include proof that she lived somewhere else, and then it'll come off. So this is the million-dollar question. Is there any way to clear an eviction from somebody's record? And the answer is basically no. There's no way to remove an eviction from a consumer's tenant report if the court entered judgment for the landlord. That information will stay on there for 7 years. It'll time off by itself in 7 years. As I mentioned previously, if a case was filed, but your client moved out, the case might have been dismissed. And because of the law that says information's got to be 100% accurate, the record should say that. It should say, you know, this case dismissed. But it should definitely not say judgment for plaintiff, the plaintiff being the landlord. Especially if your client and the landlord worked out an agreement and the case was dismissed, or if she moved out and surrendered the keys before the court date, at least in California, you can't have a judgment entered against you for that. However, if the tenant didn't show up to the court date, a judgment might have been properly entered against her. So if she didn't show up to the court date, and she didn't follow the processes for surrendering the keys and entering a notice of surrender, that's in California, you've got to check your local law for that. But generally, if somebody doesn't show up to the court date, a judgment might have been entered against her. So if your client if there's an eviction going against your client when she comes to see you at the shelter, when she moves out, she should still go to court on that day and tell the judge, look, Your Honor, I moved out. I've been living at this other place for 2 weeks, 3 weeks, and I have not been living there, and I'm a victim of domestic violence. Which could help avoid a judgment being entered against her in state court. Now, if the information is inaccurate, remember, as said, the consumer, your client, may file a dispute to have the information updated to be 100% accurate. Now, sometimes a landlord might voluntarily agree to set aside an eviction judgment. So that's something you'd want to see your local legal aid office or something like that about. If a tenant moved out and is on good terms with the landlord, you might want to see if you can get that set aside, but you generally would need the assistance of a tenant's rights attorney for that. So California law, there's a California law that is more protective of consumers than the Fair Credit Reporting Act, and this is important for clients who have criminal records. Criminal records in California can only be reported for 7 years, and that arrests-only records can't be reported. But unfortunately, this law does not apply to evictions. Evictions can be reported if they were filed and dismissed, but they can't be inaccurate. So remember that. They got to be 100% accurate, and they've got to say, they can't say judgment for plaintiff, and they can't say just simply the case was filed. If the case was dismissed, it needs to say it was dismissed. So we're going to skip over to a little bit more information on credit here. Here are the estimated effects of various things on your credit score. If you have a maxed out credit card, this is basically the effect on a good credit score. A 30-day late payment will have these effects on your credit score. If you have debt settlement, if you settle a debt for less than the full amount, it's still going to negatively impact your credit score. But if you notice, a foreclosure and a bankruptcy don't negatively impact, they impact your credit score negatively, but not a tremendously large amount. So if your client's freaked out because the house is going into foreclosure and the effect on her credit score, that's not necessarily going to impact her credit score too badly. And foreclosure also stays on, it's a negative piece of information, right? So foreclosure stays on your credit report for 7 years. Bankruptcy, however, does stay on your credit report for 10 years. So let's ask, what is the best way, and Carla's going to launch another poll here. We're going to ask, what is the best way to improve your credit score? So if you see the poll there we go, the poll's open, okay. So go ahead and indicate, what do you think is the best way to improve your credit score? Hiring a debt settlement company? Trying to make the abuser pay the debts? consolidating debt onto a credit card, or building good credit and waiting for the old debt to time out. So while you guys answer that one, I'm going to go ahead and talk about the next screen, and then we'll come back to the poll results. Oh, well, that kind of gives one of them away, but we'll go ahead and cover that anyway. Okay. Credit repair is frequently, pretty much always, a scam. There's no such thing as a quick fix for credit repair. You might see things advertised on TV. Your client might get letters in the mail, especially, there's a big push in the Spanish-speaking community for credit repair and debt consolidation, debt settlement, basically, debt settlement companies. In the same way that that anything that advertises about your credit report and credit score on TV is a scam, anything that advertises on TV about settling your debts is generally a scam. There are a large number of debt settlement companies out there that are advertising aggressively to people with a lot of debt, especially, after the economic crisis occurred. A lot of people lived on their credit cards for a while there and have high credit card debt. There is no such thing as a quick fix for credit repair. Debt settlement companies and credit repair companies take consumers' money, and if they say they can improve your credit score in 30 days, what that means they're doing is that they're filing frivolous disputes. Remember, we talked earlier about filing a dispute on your credit report. Well, you want to file a dispute when there's actually something inaccurate. You don't want to file a dispute about debts that are your own, that you actually owe, because those entries would get removed briefly and then they'll reappear, and then you get flagged as a consumer who's abusing the system. So credit repair companies are a scam. They take consumers' money and they file frivolous disputes. Debt settlement companies are also a scam. They take consumers' money for fees and they never settle debts. They can take thousands of dollars in fees and never settle debts, and then the consumer stops paying and stops communicating with her creditors, and she ends up with lawsuits filed against her, and a whole bunch of other, it's sort of a cascading pile of problems, because she's no longer in control of her own debts. She's handed over permission to settle her debts to another company that doesn't actually do that. So do not encourage your clients to do debt settlement. That anything that sounds too good to be true is really going to be too good to be true. So let's go ahead and get our poll results up. Let's, Carla, if you can put the poll results up.
Okay, so it looks like most people at 88% pick build good credit and wait for the old debt to time out. And then 5% selected hire a debt settlement company, another 5% selected consolidate the debt into a credit card, and then 3% of our audience members selected try to make the abuser pay the debts.
Well, good. It sounds like most of you guys understand that these debt settlement companies that are advertising out there are not really legitimate companies. The best way to improve a credit score, the consumer's best friend, is time. 7 years sounds like a long time, but it's really not that long. You want to encourage your client to budget properly and try to not incur additional negative entries. You want to help her to build credit. Secured credit cards are a good way to build credit. So if she's got $300, she could get a credit card with the secured card and use that carefully and pay it off every month. You can use asset building techniques, like here in California, we have United Way Bay Area encourages the use of peer lending circles, which is a bunch of people getting together to work together to lend each other money, and that information gets reported on your credit report. So you may want to talk to if you've got any sort of local economic self-sufficiency nonprofit organizations that could help point you towards peer lending circles. You want to encourage your clients to use credit cards carefully. She wants to pay the balance down if possible and try to keep less than a 50% debt to credit ratio on each card. If you've got a couple of cards with a zero balance and a couple of cards that are maxed out, that's not going to be as good for your credit score as 4 cards that are at 30% each. So sometimes it's okay to open an additional card, but don't charge a lot of stuff to it. So here's our answers to a poll. Debt settlement companies really are basically a scam. I have not seen a single one that is legitimate. As we talked about earlier when we talked about marital debt, the abuser can only be forced to pay reimbursement through family. The family law court doesn't have any power over the credit card company, right? So if they're married, you can try and use the family law property and debt distribution order to try and get him to pay. But your client needs to be paying and then request reimbursement. If they're not married, the only way to try and get the abuser to pay is through a small claims case. And either way, if your client is either a joint or individual account holder, she is going to be liable to the creditor. So it's even if the abuser is responsible, the survivor of domestic violence needs to take control of her credit history and deal with her creditors directly, because trying to make the abuser pay is pretty much a losing proposition, especially since a lot of time he doesn't have any money or he won't pay. Credit cards have pretty high interest rates, so consolidating onto a credit card can be extraordinarily expensive. There are a few nonprofit debt consolidation credit counseling organizations, but anything like that is going to end in a .org on their website, right? They're not going to have a .com at the end of their website. And be very, very careful about any debt consolidation company, and pay very close attention to the interest rates. Most credit cards, especially those available to people with bad credit, are somewhere around, the 24% interest rate, and that's extremely excessive, and that's not a good way to manage debt. The best option is really just to wait and try to explain bad credit to landlords. So when we talk about prioritizing debt, there's two major kinds of debt. We have secured debt, which is stuff that's secured by a piece of property, like a car, or a mortgage, which is secured by a house. But then all the other stuff, credit cards, student loans, medical bills, and personal loans, they're unsecured. So you want to encourage your client to pay her family necessities first and make sure she pays housing costs. There's obviously the risk of losing property if secured loans go unpaid. So the debtor should pay her car loan and insurance if the car is a necessity to get to work or childcare. But unsecured debt, credit cards, medical debt, other loans, there's little immediate risk for not paying this stuff. You don't want to pay if there's a good legal defense to the repayment, like we talked about identity theft. We also do not want to encourage our clients to enter into a repayment agreement for small payments on an old debt. There's what we call a statute of limitations, which means a limited amount of time that a debt collector can sue, and that varies by state. So you want to look that up in your state and see how long you've got, how long your client has since the last payment for the debt collector to file a lawsuit. Now, court judgments are scary, but for low-income folks, it's very hard for creditors to collect. So if your client is on very limited income, then just because she has a debt collection lawsuit filed against her, it's not the end of the world, because benefits are all exempt. So TANF benefits are exempt. Federal benefits like SSDI and SSI are exempt. Unemployment insurance is exempt. And then most states have a claim of exemption for wage garnishment for low-income folks. Again, this depends on your state debt, and when I talk about this in California, I go into greater detail, but unfortunately I don't have multi-state information readily available for all of this because I'm here in California. But it's an important question when you evaluate debt, whether or not your client should be settling that old debt. We never want to encourage small payments on an old debt. If your client wants to settle a debt, you want to save up that money and offer a lump sum payment. So debts accumulate at an interest rate that is set by statute. In California, it's 10%. And many small payments, so if you're paying $50 on a $6,000 debt, you're really not even going to be hitting the interest rate on that. Many small payments do not even pay the monthly accrual of the interest. And the debt collector's job is to get your client to enter into a payment plan, because every payment extends their right to sue. So to settle, your client should save up the money and making a lump sum offer. This is something you could help your client to do, help your client to settle. However, settled for less than the full amount is still a negative entry on a credit report. If you recall back to the slide where I have the FICO scores up there, settled debt is still a negative impact on a credit report. So sometimes it's really better to just let this stuff time out, especially if she has multiple small old debts. So a decision should be made whether to pay off some debts or to wait out the 7 years. If there's a lot of debts, it's usually better to wait. If the debt's all old and the right to sue has expired, it's usually better to wait. And many consumers simply can't afford to settle enough debt to make a difference. So you need to counsel your client that just because she has bad credit right now, the best thing to do is to work on budgeting, prioritizing, building good credit, and let this stuff time out. So the right to sue is limited by law, as I mentioned. So you want to look in your local state for the statute of limitations for a contract. In California, it's 4 years from the last payment. So check your own state law for your local statute of limitations. Because each payment resets this time limit, it's better to make a lump sum payment. Old debt should really be let time out from a credit report. You never want to encourage your client to make payments on a debt that is beyond the statute of limitations unless you've got something in writing that says settlement of the debt is a condition of providing housing. Some states do not permit the reawakening of a dead debt, but California does. So we call that a zombie debt. So we don't want to encourage your client to create a zombie debt by making payments on a dead debt, because then the creditor can sue again if she made payments on an old debt. One of the things we can do to ask the debt collector to stop harassing is to send what's called a cease and desist letter. Every debtor has a right to ask the collector to stop calling, but doing so can leave the debt collectors only one option, which is filing a lawsuit in court. For clients whose income is exempt from collections, it's a very good idea to send a cease and desist letter. It's also okay to send a letter explaining the domestic violence and her temporary inability to pay. You can ask for no calls and just letters. So if you want a sample letter for that, I can send you one of those too. You send me an email and I'll send you a sample letter. This is sort of a resource for you to hold on to. You can take a look at this. This includes sort of the life cycle of a debt and when it gets reported on a credit report, and sort of what your options are. It's a visual breakdown of the last few slides, so I won't go over this in greater detail, but it's sort of the breakdown of the last few things I just talked about. Okay. So how do we explain these kind of circumstances to a landlord? We said there's really no way to fix bad credit, but survivors may wish to bring a letter to a landlord that explains that bad credit or explains that evictions were a result of the domestic violence. This obviously depends on your client and if she's willing to talk about the DV. Not everybody wants to talk about their abusive relationship to a prospective landlord, and that's obviously everyone's personal decision. But if your client is willing to discuss this information with a prospective landlord, we've found here in the Bay Area that we have a very tight housing market here. It's very hard to get housing. But we found landlords are receptive to a letter from us here at Bay Area Legal Aid or a letter from a shelter that explains what's going on and that the client now has a restraining order or she has a divorce or that she's no longer with the abusive person who basically was the cause of the evictions or the bad credit. I've got sample letters for that as well. So do send me an email if you need a copy of that. So Carla is going to talk for a couple of minutes about state and local housing protections in the rental housing context. Carla, are you there?
Yes, I am. I'm trying to change the PowerPoint.
Okay. Or I can just click through for you if you want.
Okay, that would be helpful. Thank you. Okay, thanks so much, Claire. That was really thorough and helpful presentation. I am going to switch gears a little bit right now. During this transition time, this is probably the best time to now mention the secret code word for New York attorneys who are seeking CLE credits. So for folks who are attorneys in New York and are seeking CLE credits, the secret code word is holiday. And so those folks can go ahead and send me an email at knhlp@nhlp.org and send the secret code word holiday to me, and I can go ahead and send you a certificate for CLE. Okay. Advocates working with survivors who are experiencing problems with accessing and maintaining housing due to bad credit that's related to the abuse should also keep in mind that there may be federal and/or state as well as local housing protection for the survivors. So, for example, the Violence Against Women Act, which is the federal statute that protects survivors, was just reauthorized on March 7th earlier this year, and it provides many continuing as well as new protections for survivors. And we don't have a slide about VAWA in this particular presentation, but I would encourage folks to be on the lookout for a webinar that we will be holding in June, so in a couple of months of this year, where we will go over in detail the housing protections, both new and continuing protections for survivors. And so please, feel free to sign up for the webinar and participate. I will now cover briefly some state and local housing protections. We obviously don't have time to cover these kinds of protections for all 50 states. NHLP has created a publication called State and Local Law Compendium, Housing Rights of Domestic Violence Survivors, which is available at that URL that you see on your slide. And basically this compendium is a listing and also a summary of the various state and local laws that provide protections for survivors. And it's all listed in one place. So folks, in particular, so you can go ahead and just look for their state and then go down to the particular page that covers the protections of that state. I will give you an example of here in California of certain protections are available for domestic violence survivors. So under California Code of Civil Procedure, Section 1161.3, a landlord cannot evict a tenant based upon acts of domestic violence, stalking, or sexual assault against that tenant if the tenant has either a restraining order or a police report, and the person named on the restraining order or police report does not live in the same unit as the tenant. Folks, advocates, and their clients should also keep in mind, though, that if the tenant cannot use this law if he or she has used this law in the past and is now allowing the abuser to visit, or the abuser is a threat to other tenants. So that is a particular exception that folks should keep in mind when trying to use that provision. Additional protections available under California law. Folks should look to California Civil Code Section 1941.5 as well as 1941.6. Under these provisions, landlords must change the locks 24 hours after receiving a written request and proof of domestic violence, sexual assault, or stalking from the survivors. If the landlord does not do so, does not change the locks, then the tenant can do so. If the landlord follows the law, the landlord cannot be liable for locking out a perpetrator of domestic violence, sexual assault, or stalking. And this law applies to all the tenants. Actually, all of the laws that I'm talking about under California apply to all kinds of housing, so not just federally assisted housing, as is the case for the VAWA, the Violence Against Women Act. California Civil Code 1946.7 is the early lease termination provision that we have here for survivors in California. The law permits survivors of domestic violence, sexual assault, and stalking to terminate their leases upon 30 days written notice to the landlord. Along with the written notice, the survivor has to provide to the landlord either a police report or restraining order issued within the past 180 days in order to document the abuse. Just a note here, the National Housing Law Project, along with the California Partnership to End Domestic Violence, currently has a bill in the legislature. It's Senate Bill 612, and it proposes to amend this particular provision, 1946.7, the early lease termination provision, in three important ways. It expands protections to survivors of human trafficking. It allows survivors to provide other forms of documentation in order to show the abuse. So the current law says survivors, in order to document the abuse, you can only use a police report or restraining order. Senate Bill 612 would allow a survivor to basically use documentation provided by a qualified third party. So that includes domestic violence counselors, sexual assault counselors, medical professionals, as well as social workers to provide certain kinds of documentation. And then finally, the Senate Bill 612 would also include some confidentiality provisions which currently do not exist. Folks who currently use their status of domestic violence to, terminate their leases early. That information right now landlords can use however they want, and Senate Bill 612 would restrict that. Okay, so I think we are now ready for the conclusion, Claire.
Yes. So the important takeaways that I want you guys to remember from today is that it's important to screen for issues at initial intake because that minimizes the harm to your client, right? You want to pull a credit report early. You want to see what's going on with identity theft. You want to place a 90-day freeze if she thinks that her identity is at risk for theft. It also maximizes the opportunities for those of us who are consumer law attorneys. If you all on the front lines working with survivors at the point that they separate from an abuser, if you document some of this financial abuse, it provides resources and evidence for us as consumer rights attorneys to assert her rights later. And it also provides information and documentation for a family law attorney in order to get her the best resolution in a divorce for clients who are married to the abusers. You want to request those credit reports early. You want to open individual accounts now, and she wants to stop using those joint accounts. And analyze that report for identity theft and to mitigate harm. You want to send dispute letters to challenge any sort of inaccuracy that's a material inaccuracy, right? So any information that is inaccurate that's affecting her credit or that might affect a decision that a landlord would make. We want to get that cleared up. You want to encourage your client to make a budget, to build good credit, and wait for old debt to time out. You want to discourage your client from entering into a payment plan on old debt. And you want to discourage your client from spending resources she needs to support her family to settle old debts. Because really the best thing to do is wait it out. You really want to discourage your client rather, from entering into any sort of debt settlement plan or anything that sounds too good to be true. If your client comes to you with a flyer or something from a company or something she found on the internet, it's good to give your client the correct and good information about building credit and discourage her from getting into a plan that's just going to take her money and not settle her debts. If your client's willing to talk about the DV, let's send them with letters to prospective landlords, or go with them to the bank and see if you can talk to a branch manager about getting an account open. And help prepare your client to talk about the DV if she's willing to, because that might help landlords to make an exception. They might have a rule about bad credit, but they might be willing to make an exception for somebody who's got, proof and evidence that she's starting over in her life without the abuser. Here are the additional resources I mentioned. This is me, Claire Johnson. I'm at Bay Area Legal Aid. That's my email address. Don't hesitate to email me directly. I'm happy to provide resources. Or pick up the phone and call me. I'm happy to provide information over the phone or help talk through a particular client set of facts with you. The National Consumer Law Center has this book for $15 that discusses, in a little bit more general terms than I've covered today, some of the consumer rights of domestic violence survivors. The screening tool I mentioned is at csaj.org. So go ahead and you do a search for economic justice at CSAJ, and the screening tool will pop up. NOLO is a good resource for people who are dealing with legal issues themselves. So if locally in your local state you don't have access to a consumer rights attorney, you can go to the NOLO resource to try and help your client work through, you know, a debt collection lawsuit or something like that. So that's the end of our presentation. Carlo will go ahead and read off. We've got about 13 minutes, it looks like, for questions. So Carlo will go ahead and read off some of the questions, and I'll go ahead and answer some of those. I'll go ahead and hand it back to Carlo here.
Sure. So for folks who are